Okay, so welcome. Most people start off happy hour on Friday afternoon in a different setting. You guys decided that coming and hearing about forms would be the exciting way to start your weekend. So I don't know if congratulations are in order or not. My name is David Sanders. I am General Counsel for the Greater Las Vegas Association of Realtors, and today we're going to be talking about the forms that are going live on October 1st. There's about 4 new forms and then updates to about 4 more. For those of you who are concerned because you remember 2016 and 2017, the forms update this year is not as dramatic as those years. In fact, there are no changes to the residential purchase agreement. Again, there are no changes to the RPA, so you all can take a deep breath. But there is a lot of good information that we're going to have today. So the forms, and you all should have a packet, and the packet should contain a document entitled the Buyer's Notice of Disclosure, a Notice of Cancellation of Purchase Agreement, a Buyer Brokerage Agreement Early Termination Addendum. There should be a Residential Lease Agreement. There should be an ER and an EA Listing Agreement, and a Buyer Brokerage Agreement. Okay? If you don't have those, you can step outside and Jessica will take care of it and get out paperwork. Oh, there's also the net sheet. I keep forgetting the net sheet. And update to the net sheet. So, I'm going to go ahead and jump in and start talking about the new forms, and then we'll jump into the forms that were changed. Again, if you have questions, feel free to raise your hand and just wait until Jessica comes over with the microphone to get started. So, the first form we're going to talk about is the Buyer's Notice of Disclosure. GOBR used to have several standalone disclosures: pest notice, mold notice, gaming, those kinds of things. And the idea behind this form was to take all of those and then add some more and have an overall general disclosure for a buyer. So the existing ones that were incorporated into this that were not changed from before are the pest notice, the soil notice, mold, flood hazard, the fact that there's airport noise, gaming, and then for your protection. So those have not changed. What we have added, the first thing we've added is, this is on page 2 of the form, golf courses. For those of you who have been around for the last about year and a half, golf courses closing down and changing away from a golf course to either high-capacity, high-rise living or apartments or condos is a very big issue in Southern Nevada. It's not only a big issue in Southern Nevada, it is an issue nationwide with the decrease in the amount of people who are playing golf. Just in our valley alone, we have about 3 different scenarios. You have, of course, Silverstone, which the HOA was supposed to run the golf course. You have Badlands, which I think every lawsuit in Clark County involves their Badlands right now. And then you have Legacy out in Henderson. Now, each one of those has a different explanation behind the golf course closing in different scenarios. For example, Silverstone, their HOA, their CC&Rs actually require them to run a golf course. I think that lawsuit might actually have some success. Badlands, however, is a scenario where there may or may not be zoning restrictions, which is probably why there's 18 lawsuits involving Badlands alone. And then Legacy out in Henderson is even more unusual because it's a deed restriction, meaning that the land that's the golf course has a restriction by the city of Henderson that it can only be run as a golf course. And so rather than creating a 19-page golf course disclosure, what we're doing in this scenario is we're just telling the buyer that, hey, you need to go out and independently verify the golf course. Now, the upside about the 3 scenarios that I've talked about today, most of them you'll be able to find in the title report. The CC&Rs will identify whether or not the golf course will be running. The deed restriction would show up on the property nearby in Henderson. But the idea was to make it so that you don't have to be experts on golf course conversion, but just to simply let the buyer know that if they want to buy a home on a piece of property that is near a golf course, they really need to do their due diligence. For example, I know in Southern Highlands Donald Ranch, they're having conversations right now where they want to change the golf course and add additional development. So this is not an issue that's going to be going away. So the idea was to put it in a buyer general disclosure. So when you first get and sit with your buyer before you go out and look at a variety of homes, you kind of give them an idea of what the issues are with the market and how golf courses can potentially deal with them. The next update to this is, of course, solar panels. And the solar panels in Southern Nevada are a very interesting thing. They were really, really dynamic, and now I'm not so sure they seem to be coming back. But as you guys all know, if you have a transaction involving solar panels, it can cause the wheels to come off the bus very, very quickly. So the disclosure to the buyer at this point is to say, hey, if there's solar panels, they may be purchased, meaning that the seller will own them and can transfer title. They may be financed, which means they got a loan, or they may be leased. And each one of those, depending on the agreement with the solar power entity, will have an impact on the transaction. For example, if it's a lease, the lease agreement probably has a provision in it that states that the solar panel company gets to do a credit check and gets to approve any kind of a transfer. And if the credit score of your buyer is not super strong, we all know that can create a problem. So the idea is to get this information to the buyer ahead of time before you go look at houses, just so that you're aware of this scenario. Conservation easements, that's a really fancy word for the Southern Nevada landscape program they have, Smart Landscape. Why we went with the phrase conservation easement is that's what it's entitled in the statute. So there's a specific statute in the Nevada Revised Statutes that allows utilities like the Southern Nevada Water Authority to create these types of easements. As of today, on the 14th of September 2018, Southern Nevada Water Authority is the only group that is doing this. That doesn't mean that tomorrow Nevada Energy or any other sort of conservation group could create this type of easement. The ability to do so has been created in statute. So that's why we went with conservation easements, just in case somebody starts doing this tomorrow, we don't have to change our forms, okay? This will show up on the title report, okay? I know that this is one of those things that can potentially come up. So if you are looking for, if your client is looking for a pool home, or they want to put a pool in, this is on title. So it'll show up if you go to the recorder's office. It'll be known as a conservation easement. That will be able to tell you. So if you are looking for, again, a client who's looking for a pool-based home, or they want to put a pool in, or they've got animals and they want to make sure they can put grass in the backyard, as a buyer's agent, you may want to consider doing a quick check on title so that 90 days into the transaction, right before close, they find out that they can't put a pool in the backyard because of this easement. I do know that you can address this in a variety of different ways, but doing it 2 days before close is pretty difficult. And I know that the Water Authority has a process by which you can buy it out. Because what the Water Authority did is when they used to make all their money when they would put in new homes and give them water access. When the recession hit and people stopped building new homes, the Water Authority went out and bonded out based on these things. So if you take that easement, they've gone out and bonded out with a bond company for that amount of water. So if you want to go in and get out of the easement, there's a calculation that has to be done based on that bonding. I know half of you are already asleep, which is why it's not a great thing to deal with this. Then you have to go into the Water Authority and request a buyout and then make that payment. So much better to be aware of that potential problem going forward rather than right before close. Let's talk about home security systems and video surveillance. And so we put this in here to tell the buyers that sellers may have home security systems, ring cameras, etc. There is no requirement in the state of Nevada for a seller to disclose there is surveillance in their home. I'm going to say that again. There is no requirement for the seller to disclose that there's surveillance in their home. The only time they have an obligation to disclose that is if you have an expectation of a right of privacy. But you're a buyer going into someone else's home, I don't think you're going to have that. It's primarily designed to stop security cameras in like gym locker rooms. It is not designed for an open house. So this is put in there so that you can have a conversation with your buyers that every time we go into a home, you have to assume that we are under surveillance. It is not unlawful for the seller to take that security video and watch it. So if you're in the back saying, see all that back damage in the bathroom, we could probably ask them to drop their price by 5 to 10 grand. Or if they say, this is our dream home, we'll pay any amount of money, the seller can use that. It is not illegal in the state of Nevada, okay? They don't even have to tell you it's there. Now, if you have seller clients, I would tell you that misusing video surveillance is also a problem as well. So if you've got buyer clients, I would be telling them, look, go through the home, make mental notes of things you want to talk to me about. We're not even going to talk about it in the driveway, because if they've got a Ring camera system, they can pick up what you're saying in the driveway. So let's have our conversation, let's have our strategy about whether or not this is a house you like, what we want to offer on it. Let's have that in the car. Let's have a call afterwards, okay? Because I think this is an issue that's only going to get worse, and I don't anticipate the law in Nevada changing to require the disclosure. So for those of you who read 1984, you have to assume that Big Brother is listening and watching at every time you go through the course, okay? Smart homes. So this one came out because there's an increase in quote-unquote smart technology in homes today. And the story that kind of prompted this was there was a buyer who bought a home and it had a computerized thermostat. But they did not get the information, the passwords and the settings. And the new homeowner had bought a home with the same thermostat but had not updated everything. So the seller in their new home is wondering why the temperature isn't being decreased while they decrease the temperature on their smartphone. And then the buyer in the house is wondering why it's 65 degrees and they can't decrease the temperature. The reason is no one thought to say, hey, that really cool digital thermometer, can you give me administrative access so I can reset the passwords and not run into that? So that's going to be a discussion. Now, I don't know about you, I'm not an expert on smart technology. It's really just designed to say, hey buyer, if you think that thing is really cool, you want to buy a home with this information, let's make sure to ask for those account passwords and things like that to make sure that that transfers along, ideally at the close of escrow. Okay? Any questions about that? All right. The next update is the home warranty language. It is language that says the benefits of a home warranty and giving a buyer a place to mark whether they want one or they don't. Mostly it's designed so you've got somebody that you had a conversation with. The next provision that we added is rental restrictions. So this is rental restrictions in two fashions. It is the HOA that says we won't allow any type of long-term or short-term lease. It's also to address the quote-unquote short-term lease as well. Because if those of you are anything like me, you open up the apps of a variety of vendors and you would think that short-term rentals in Southern Nevada are lawful because there are a lot of them. As of today, they are unlawful in the city of Henderson unless you are at the hotel condo unit at Lake Las Vegas. They are unlawful in unincorporated Clark County. And they are unlawful in the city of Las Vegas unless you have a special use permit from the city. Now, these apps and websites who offer these types of short-term rentals, they put all of the liability to verify compliance with local statute on the host. And I am sure that you're going to get questions from people saying, I want to buy an investment property that I can put short-term rentals into because between the Vegas Golden Knights, who are going to win the Stanley Cup in 2018-2019 season, and the Raiders coming in 2020, I'm going to make all kinds of money off of sports fans coming to watch. And the reality is the legal landscape is not as conducive to short-term rentals as most people think. So putting this disclosure in so that you don't have a very angry buyer who finds out that they can't use this as a short-term rental, that's what this provision is for, okay? Now, as we speak, the city of Las Vegas is attempting to revamp its short-term rental program. I also know nationwide, cities like New York and San Francisco are taking a look at restricting these types of things as well. This is not an issue that's going to be going away or reaching a resolution anytime soon, so I would make sure that you go over that with your clients. Okay, the last page of this is a hold harmless. It is saying, Mr. or Mrs. Buyer, we have had a conversation about all of these scenarios that could possibly come up, pests, short-term rentals, etc., and you're going to hold me as the agent in my brokerage harmless if the property, for example, the golf course closes down and you don't live on a golf course, or you can't do a short-term rental. It's designed to protect you from being sued by your buyer in the future. Okay? Any questions about this form? Yes, ma'am.
So this condenses.
Wait for the microphone.
Okay.
Thank you.
So this condenses the current forms all into this?
Yes.
So instead of having the 3 that we normally would do, we just now have 1?
Yes.
Okay, that's what we're wondering about.
Yeah, and I know some of you will probably cry when I tell you this, but the beltway disclosure has gone away because the beltway is done. Sorry about that. Okay. Next question.
With regards to Southern Havana Water Authority easement,
Yes.
I would call the SNWA with regards to if the buyer were to pay off the easement, if they could, and they told me that the buyer cannot install any irrigation, plant grass, or pool or pond, even if the buyer pays off the easement.
So, to make sure I understand your question, you're saying that you've reached out to the Water Authority and they've said no. It's the Southern Nevada Water Authority, not Las Vegas, so there is a way to petition to get the easement lifted by buying out the bond. It is a pretty complex process that I don't know specifically how to do. I know it's a possibility because I've had conversations with the Water Authority on it. I know it's not easy. Michael? If you wouldn't mind.
So David, what I'm hearing, and I want to confirm that we should do this the same time we do our duties owed right away, go over this form with the client, versus going out and showing them.
Yes. For example, the previous disclosure forms had a specific address, which to me implied that you would only be pulling out the pest disclosure, the mold disclosure, once you've shown me 1, 2, 3, 4 Main Street. But in reality, from having conversations with practitioners, it was primarily used as you're sitting down and saying, let's go over some general conditions of the real estate market and what you're looking for in Las Vegas. So we took this specific address away so that you could have the opportunity to use this form anywhere along the line of your showing process. If you wanted to do it at the very beginning, you certainly could. If you wanted to do it before you looked at it, after you looked at a specific home, you certainly could. The idea was to give you more variety, and that's going to be a business practice decision that you and your brokerage would have to make. But we decided to give you the flexibility if you wanted to do it at the very beginning, that the form would help you do so. Yes, sir.
If I see correctly, there's at least 2 of these disclosures that are also in the RPA. Would you also foresee a RPA being modified to remove a few of these?
Are you saying the resident?
Or harmless and the affordableness?
No, and let me tell you why. Because this is a general disclosure that you give as an agent to a buyer. The RPA is the seller and the buyer having a contractual obligation saying, for example, golf courses are there, but the seller and the buyer agree, the buyers can do their own due diligence as to the benefit of the property. So this is really designed to protect you as an agent, whereas the RPA is an agreement between the buyer and the seller. Okay. Yes, ma'am.
this form going to be required on every transaction?
GOBR forms are not required. We provide them as a member benefit, but we cannot, the association can't force anyone to use them specifically. That would be a conversation you would need to have with your broker as to whether or not they're going to require certain forms.
Is the agent's name going to appear in here by default if it's in the transaction desk?
If you auto-populate the agent's name, then yes.
Hello.
Hello.
Will this replace the existing 3 disclosure forms, or will those
Yes.
still be available?
They are going to replace them.
They'll be, okay, thank you.
In the back.
Hi, David.
Let's go.
Good, thank you. The smart home clause.
Yes.
Is that currently within the RPA?
It is not anywhere. This is the first place to disclose it.
Do you recommend then within the RPA with respect to getting access codes and things of that nature? Certainly, we're not smart enough to identify
Well, I
that.
think you're smart enough to identify.
A
You're here
thermostat.
learning about forms on a Friday afternoon. I think you're right. So the idea was to put it here and see if we needed to update the RPA. If, for example, there isn't any smart technology in the home, provision isn't required. This has been kind of a recent trend that we're trying to get ahead of with the increase of different types of thermostats, cameras, those types of things, and just trying to see if it does need to be added into the RPA. In the short term, what I would be doing if I was a savvy real estate professional, I would be looking at the home. And you know how buyers are, they get really excited about the shiny thermostat. They say, this is really, really cool. Well, okay, if you want to buy this home, let's make sure we get all the necessary passwords so that you can control that. The idea was to give you the information, and then all you need to do is just include a quick sentence in the initial term, so to provide all necessary access codes and information to access any and all smart technology, something like that. But we'll be looking at it, and if it becomes something that we think we need to add to the RPA, we will. Okay.
Are you looking at possibly coming out with a separate radon disclosure, or could it possibly be incorporated into this form down the road?
As of right now, so the question was, do we have a radon disclosure? The answer is we don't as of yet for a variety of reasons, but we are mindful of specifically Henderson, where that seems to be an issue, that we are keeping an eye on. The biggest problem that I see just from, there is a state disclosure form about it, that the division that is available, that I'm aware of. But the problem is most, if not all, of the radon testing companies that the form recommends are all in Reno. So I just don't know how much, it is certainly an issue with certain parts of Henderson, but I don't know if we have a solution for that as of yet. Yes, ma'am. You only get 2 questions, so you're burning through them real quick.
I closed a transaction recently that had an issue with plumbing, outlawed plumbing, and there was no way for us to find out about it. It wasn't Kitech, it was another plumbing. So that's one thing that's been on my mind lately about disclosure, about researching, looking up plumbing pipes that have been outlawed. I mean, this is a big issue.
So typically, if there's problems with the plumbing scenario, it's going to come through a construction defect lawsuit, and there will be a record on title of a Chapter 40 lawsuit. If there is a Chapter 40 lawsuit and there's an HOA, NRS 116 requires that disclosure. You're right in the sense that it's going to be difficult for you to go out with a backhoe and dig up and see if there's plumbing failures. But again, if you're a seller's agent, it's within your reasonable knowledge. You don't have to go out and do an investigation. The seller doesn't know, the seller doesn't know. Buyer, I would be defaulting primarily to inspectors on that to make sure that they get that. It's really just within the knowledge of each party. So I would say as long as you stay within the 4 corners of your real estate license and don't go off into investigating different types of scenarios, you're going to be fine. Any other questions about the buyer's disclosure form? Congratulations, that's the biggest change we have this year. There's other important stuff we're going to talk about, but that's the primary largest as in form one. So let's talk about, the next one we want to talk about is the buyer-broker agreement early termination. So if you have a buyer brokerage agreement and you want to terminate that, or if the buyer and you reach an agreement, that's what this form is designed to do. It's designed to give you a way to terminate that agreement. And as you can see, there are a variety of ways, depending on what your broker recommends you do, to end the agreement. Paying a flat fee, paying direct expenses, getting an unconditional withdrawal, or other, and you can put the additional terms that you want right there. So if you have a scenario where you need to terminate the buyer brokerage agreement, this is a document that you can certainly use. I know some offices have their own, but the idea was to create a one-page form to give you a place to start if you want to terminate using the buyer brokerage. If you have specific questions as to which one of those 4 options you should use, that is a question that you need to take to your broker, and it may depend on each of the situations as to why you're ending that agreement. So if you are agents, definitely go down and sit with your broker and figure out how your office is going to use this. If you're a broker, ask yourself how you want to use this. Okay? Any questions about this one? Okay? The next one, and this is one that I'm very excited about, it's the notice of cancellation of purchase. And it's making me very, very excited that we finally have a form like this. This is like 2.5 years of my life in a single page, which is kind of depressing. So let's walk through what this form is. So it's first thing it is, it's cancellation of purchase agreement. So if you have the residential purchase agreement, vacant land, any one of the association's purchase agreements, you can use this form if things go south and the buyer and the seller just can't reach a deal. So the first thing it does, it cancels the contract for a variety of reasons. If you'll notice under number 1, it says what provision of the RPA or the purchase agreement you're canceling. 2A, 2B, 7, due diligence, etc. Any one of those you would be able to identify. Per mutual agreement, so the parties just decide we're going to cancel, or other, if we need to explain the reasons why the agreement is going to be terminated. The next section allows you to cancel escrow. It's a separate section so that you can cancel escrow, and then if it's an issue with earnest money, it's the release of the earnest money deposit. So you can cancel escrow, you can cancel the contract, and you can reserve the right to address earnest money. So the earnest money is going to be either, seller's going to release it to the buyer, buyer's going to release it to the seller. They're going to split it, which would be number 4, and other, whatever number that is. Or number 3, hold it until either we give you additional instructions or a judge gives us an order. Because at the end of the day, those are the 4 things that happen. Buyer gets it, seller gets it, they split it in some type of scenario, or a judge tells the escrow holder how to release the funds. Okay? I know you're all excited to ask questions. And then at the end, there's a mutual release. We are ending the agreement. All of the other obligations under the purchase agreement are hereby. Okay? 1-page form. We did get some feedback from title on this, so we don't anticipate a lot of pushback from title. We hope that over time that everyone will just start using this form, so you don't have to have 17 different forms depending on which title company you use. I can't guarantee that, but that is the idea behind this form. Are there any questions? Yes, ma'am. Please wait for them.
So we don't need addendum for cancellation anymore?
Again, you could use any form you want to. The problem with using just the straight addendum was that you were drafting language and sometimes you could miss things. So the idea was to give you a form that addresses all of the potential scenarios. So you technically could. I would recommend that you use this form. Anybody else? Steve in the back.
Oh, Steve, where are you? Didn't see it.
With regards to,
Oh, no, I walked all the way over.
you walked all the way over here.
I know. You heard her. know who's in charge today.
With regards to the first one, is
Yes.
permitted by good faith. I mean, if one's canceling pursuant to the due diligence period, one really doesn't need good faith in order to.
But we need good faith in the sense that we are terminating pursuant to the good faith exercise of this provision. It is our right, we're enforcing it that way. I understand your concern that would be that, you know, if the parties don't reach an agreement, this document isn't going to be executed and the parties will be able to go ahead and, you know, if I think that you are not exercising good faith under 2A, I'm not going to sign this as the other side and we'll go down and fight it out in the courthouse. So,
Do you think in a future revision under definitions, we should have a definition of good faith?
Possibly. Good faith is primarily in that scenario designed for the judicial officer to review, who has a very good opinion of what good faith is based on the scenario. That's going to be a factual analysis. Possibly, you know, we always look at forms and see if we're going to review them. I was really excited that we finally had a cancellation form. It kind of boggled my mind that we didn't have one before. So yes, we'll take a look at it if it becomes an issue.
One follow-up comment.
Okay.
I'm glad to see this because sometimes when we're trying to resolve a earnest money deposit dispute, people think it has to be both the contract and the earnest money.
Yeah.
It's not going to work in every case, but this enables you to cancel the contract, get the property on the market,
Yeah.
and then we could go to mediation
Exactly.
or whatever, some other
Yeah.
form.
Exactly, and that, so for those who didn't hear Steve's comment, the concern was, oftentimes people think that if there's a dispute over earnest money, you can't cancel the contract, can't cancel escrow, which is not true. The parties just reserve the right to fight over the earnest money deposit. It allows you to cancel escrow, allows the seller to move forward with purchasing the house, it allows the buyer to go ahead and start looking at other properties. And this form is pretty common everywhere else in the United States, something similar to this. Any questions about this form here? Okay. Okay, so those are the new forms that will be going live on October 1st. Let's talk about the forms that have been changed. The next one I want to talk to you about is the residential lease agreement. It looks incredibly intimidating, but it is not. And like everything else involving property managers, we get to talk about squatters today. So, AB 161 was a legislative bill from the 2017 legislature. The idea was to protect and help police enforce against squatters. And so the bill requires certain things to be done incorporated in a lease agreement. It requires, for example, if you look at the first page of this thing, a disclosure in font twice the size of everything else in the lease agreement. That's basically the first page. Okay? It requires the property owner's address and contact information to be in the document, which is on page 13. And it requires the lease to be notarized. Now, the bill doesn't say if the tenant needs to notarize it only, if the owner needs to notarize it only, or both. So we put both on. So, NVA, the Nevada Association of Realtors, was successful in getting an exception to all of these requirements if you are a licensed property manager. So we will now have, as of October 1st, 2 lease agreements. If you are a property manager and you are managing the property, you do not need to use this lease. This is a lease that you would use in the scenario that I come to you, I am your buyer, and I say, thank you for helping me buy my investment property. I want to self-manage and put a tenant in there. Can you get me a lease? This is the lease you would use, okay? Which you can create as a part of your license ability as a real estate licensee. You don't need a property management license to fill this form out. So that's what this thing does. Now, let me give you a couple of interesting things about all of these requirements. If you have a lease like this that is not notarized by both parties, does that mean that the lease is not valid? The answer is no. If you have a lease like this between an owner and a a tenant that doesn't have the disclosure with 2-point font, say it's 1.5, because we all know judges look at things like that, does that mean the lease is invalid? No. What it means is, the idea behind this was this, and I'm not kidding, this is designed to help law enforcement. So that when law enforcement comes to the property and the tenant says, I'm a viable tenant, I have a lease. If it has this disclosure, if it's notarized, it has the address, it creates the impression that you are there legally. If it doesn't have any of this, then law enforcement can assume that you are a squatter and start investigating. So just because if you're a property manager or if you have a tenant that says, Your Honor, we don't have a valid lease. The reason why I haven't been paying rent for the last 19 months is not because I'm a ne'er-do-well. It is because the disclaimer on the front of my lease was only 1.25 font%. Therefore, the lease is invalid, and I am a champion of justice because I haven't been paying my lease. That is not what it is designed to do. The bill specifically says the lease is still going to be valid for the purposes of eviction and all that kind of fun stuff. This is designed to fight squatters. Okay? There are no other substantive changes to the lease than making it compliant with AB 161. Yes, ma'am.
So can the landlord and the tenant have a mutual agreement not to notarize?
Well, let me ask you this question. Can you contractually waive statutory rights? Because when I was pulled over by the Nevada Highway Patrol, I said, you don't understand. I have contractually agreed that there is an envelope around my car where the speed limit is always 125 miles an hour. So you cannot pull me over. You cannot contract out of statutory rights. Okay? And mostly just trust me on the Highway Patrol thing because they don't think it's as funny as that.
Sorry.
If we're managing our own property, we're licensed, we're real estate agents, if we're not acting under the authority of our license, should we be using this form when we're not acting as a real estate licensee? Should we use some generic form at Nevada legal forms?
So that's a very good question. And let's talk about the scope. So those of you who didn't hear Steve, the question was, if I own, me individually, as Dave Sanders, Realtor, if I own 5 rental properties, can I use the GLBR forms in my own property management for my own purposes? GLBR gives you a limited license to use the forms in relationship to your real estate business. So in that scenario, I am not sure if you would be licensed to use them. Now, if you paid yourself as a property manager and maybe had multiple personalities, possibly. But it's primarily for your benefit as a realtor. So I would tell you that if it's outside the scope of your real estate business, it's not an authorized use. Okay? Yes, sir.
You said as a property manager, you don't have to use this form.
Yes, if you are a licensed property manager, you do not have to use the AB 161 compliant lease.
Okay.
And in transaction desk, there'll be one that says residential lease agreement, and there'll be one that says AB 161 compliant residential lease agreement.
Okay. There are times, I am a permitted property manager, and there are times that I will do up a lease, but I won't be managing the property.
Use the one in your hand. So anytime that the owner is self-managing, this is the lease you would want to use. Okay? Because the exemption for all of these requirements, the notarization and everything else, is triggered on whether or not you are a licensed property manager managing the property. Okay? Yes, ma'am.
So landlords and tenants that's currently under contract right now, should they be signing this updated?
Again, so what we talked about is if you have a lease that doesn't have these provisions, it doesn't make the lease invalid. That would be a discussion that you would probably want to have with your broker as to when you would recommend clients, like if my lease is up in 90 days, I would probably suggest that you do the new form and update it and compliant. If we just signed a lease on August 1st, I don't know if it's really worth jumping through the hoops, but that would be a discussion that you'd have with your broker and your clients. Okay? All right, any other questions about, nope. That's okay, no problem. Just a side note, before you jump in with your question, I believe there are only 2 stupid questions, and I'm going to tell you the 2 stupid questions right now. Number 1, you call the Internal Revenue Service and say, isn't it about time you audit me? Okay. Number 2, you have been pulled over for speeding and the officer says, I'm going to let you go with a warning. And you say, is it in fact morally ethical for you to let me off with a warning when I'm speeding? Beyond that, fire away.
Great. So I guess this question comes as a result of us now doing the majority of our paperwork electronically with electronic signatures and requiring a notary
Yep.
for this.
They are going to have to sign it with ink in front of the notary. There is a statute we have. Nevada does have the ability to have authorized so-called electronic notaries. It hasn't gone into effect yet. That technology is still just not there. So unfortunately, yes, to be completely compliant with AB 161, both the owner and the tenant will have to notarize that form wherever they are and send it back to you. Now, fortunately, if they don't do that, again, it doesn't make the lease invalid, it just means that it doesn't help with the squatter issue. But you're absolutely right, it does create problems, particularly if you've got clients who are out of the United States and all of that. I don't have answers for that. This is just what the bill says. Hopefully, maybe next year, the legislature will take a look at this and change it, but I haven't heard anything one way or another.
And just to follow up to that, do you see any reason why you couldn't first get this signed electronically and then advise the tenant that's out of state that's moving here to get it notarized and send it over? And then
I would be hesitant to do that, mostly because the bill says it has to be notarized, which means that the tenant, the notary has to watch the buyer or the owner or the tenant sign it because there's not a separate signature line. I would be hesitant to do that just because I don't know what the potential liability would be in that scenario. Because if I was a notary and you came in and said, I need you to notarize this and it was already signed, I wouldn't notarize it. So I don't know if I would do that.
Yes, I would like to clarify, I'm not sure what I'm hearing here. If you do a courtesy listing for a rental, and then you're not going to property manage it, but can you write the lease? That's what
If you are, so first of all, I hate the phrase courtesy listing because it doesn't exist. You either have a listing or you don't.
Okay.
And so quote-unquote courtesy listing is just an invitation for liability. I thought it was a state law thing. I called Jan Hawley and he said I thought it was an MLS thing. So I don't think courtesy listing exists. Now, I don't mean that to be derogatory. I mean it to suggest that you either have a listing and all of the ethical and statutory obligations to that client or you don't. And I think we often use the phrase courtesy listing as an almost shorthand for some sort of like, I don't have a full spectrum of responsibility to the client. And I don't think that's true in that sense. What I am saying is that if you are have a real estate license in the state of Nevada, you can assist a client, fill out a lease who wants to self-manage. That is authorized under NRS 645. You don't need a property management license to do that.
And you just use this?
That would be the one you would use.
Okay, thank you.
Okay? Michael in the back.
By the way, thank you on that one. But First of all, who, when they get it notarized for the non-property managers that do this, you having two people getting their signatures notarized, who keeps the originals and what's the rules for that?
The statute is absolutely silent on that.
Of course.
I would say, we have provisions in the agreement that says electronic or copies are accessible. You don't necessarily have to have the original notary to make it valid. If, like, we had to litigate over it, I don't necessarily need the wedding. When I'd like to have it as your attorney, I don't need it. I could probably do everything. You know, best practices, would you like to have as the property, as the owner, would you like to have both of the wedding notary signatures? Yes. Does it mean that, you know, the lease is invalid? No. So, yeah. So, and you can execute it in multiple copies. So you could have one with the notary and then with wedding and the others. You could do that. And again, because it doesn't really have any impact on the enforceability of the lease, whether or not who has a notary is really only going to come up if you've got a squatter, and that would go to Metro rather than a courthouse.
So this document is used by agents that are not property managers, and why should the broker and brokerage be signing this document? It should just be between the landlord and tenant. Why are we putting ourselves at risk or liability?
Do you have a specific page that you're referring to?
12 to 14.
I'm sorry, what?
Page 12 to 14. Why should the designated property manager be signing this document?
You wouldn't necessarily have to unless you were involved for the purposes of confirmation of representation. That provision is just confirmation of representation in the sense that if, for example, I'm self-managing but I put a co-op in the MLS to get tenant referrals, that would be situation. That's confirmation of representation. It's not a signature as a party for the lease. It's just if there are real estate professionals involved in the lease representing either the tenant or the owner, this is their contact information. So they're not a party. If you look at the, if you go to the very last page, page 14, a really cool block, it says they are not parties to this agreement. This is between the landlord and tenant. It's just designation for, you know, identification purposes only. Again, so what we did with this document is we took the existing lease agreement and made it AB 161 compliant. We did not do a massive review or rewrite of the lease agreement because we felt that there was a need for this document. If we did a massive rewrite of the lease agreement, which is probably coming in 2019, it would be another 6 months before you had the AB 161 compliant lease. So there might be some inconsistencies, but the idea was to get you something that you could use in that scenario.
So you just said owner managed on that one?
So if you have a question, please wait for the microphone and raise your hand because we're recording today.
Where are you? Oh, I'm sorry. Talk loud. Okay. So my question was, so you just said owner managed instead of going through all this other stuff?
What do you mean all this other stuff?
Well, the brokerage and the designation and
I can't hear you. Can you pull
the
the microphone
broker
a
and
little
the
closer? Thank you.
designation and those other things that we were just talking about?
So can you give me a page number that you're looking at?
Yeah, page 12,
Okay.
number 43.
So the brokerage, yes, you could just strike through that, put the owner's name there. That would work under 43. You could also put it under additional terms under 46.
Thank you.
Is there anything in here that states that we as a licensee may not be licensed in property management, some type of disclosure for that?
There is not, because you're not a party to the lease agreement, and I don't necessarily think that that disclosure exists. But you would want to speak to your broker if your broker would want you to have that type of disclosure. You're allowed to create a lease under NRS 645, You don't have to have a property management license to do that. I don't know if that disclosure is necessary. And based on my conversations with the division, I don't necessarily think that would be required. But if your office wanted to do something like that, you're certainly free to create something. Okay. Last question on the lease, because we're got a little bit more to do, and I want to wrap up in the next 20 to 30 minutes. Yes, ma'am.
I just want to make sure I'm following this now. As a licensed property manager, but you're not going to manage this property, the owner's going to do it, you're executing the document.
Executing implies that you are signing as a party. You could create the document for the owner and the tenant to execute. So you could prepare the lease, but you're not going to sign it.
So it would be simply facilitating and not a party of, and so you want everything notarized.
So if you are a property manager and you're executing a lease on behalf of the owner as a duly licensed property manager, you're going to manage, you will use the existing lease. If it is the scenario where what was your name again?
Marco.
Margo? Margo, thank you for helping me buy 123 Main Street. I want to self-manage and find a tenant. Can you prepare a lease agreement for me? The answer is yes, and you would use this one. Okay? All right. Let's move on, and I'm not going to spend a whole lot of time talking about the net sheet, aside from to tell you that the net sheet has been updated. You take a look at it if you have any specific questions. I want to spend the last few minutes we have together talking about something that is not going to impact your day-to-day real estate business, but if you need it, you will be very grateful that it is here. So we've included copies of the buyer brokerage agreement and the listing agreement. Both of them, and if you want to pull the ER agreement, we can all go to the same page. We are going to be looking at page 7 of 8, number 26, damage cap. The change to the listing agreement and the buyer broker agreement is the inclusion of this provision. We have seen an increase in the number of lawsuits involving real estate agents. Buyers and sellers sue each other. They name the agents involved. They think that you have E&O insurance. They think you have a lot of money. And you're staring down the barrel of a potential multi-million-dollar disclosure because the seller failed to disclose the uranium deposit that they dug in the backyard and dropped this nuclear waste in the backyard. A damage cap provision is a contractual provision that limits the amount of damage that can be reported. So what this provision does is it limits that at the end of the day, if the seller or the buyer sues you, the maximum amount it can ever recover is the same amount of the commission that you receive. Okay? So I'm going to read through it, and we'll talk about what it means. Notwithstanding any provision to the contrary contained in this agreement, if broker shall be liable to seller for any matter arising from this agreement, whether based upon an action or claim in contract, warranty, equity, negligence, intended conduct, or otherwise, including any action or claim arising from an act or omission, negligent or otherwise in the liable party, the maximum aggregate liability of broker to seller under this agreement shall not exceed the aggregate commission amount paid that has been paid by the seller to the broker. Lawyers get paid by the syllable, so it's a very fancy way of saying, at the end of the day, if a seller sues you as a rising for damages from a listing agreement, the maximum amount they will ever get is the maximum amount of commission you receive. It is designed to stop frivolous lawsuits. It is designed to deter attorneys who just want to add you as a party because you have insurance. This is not going to impact how you do real estate on October 1st. But if I was a practitioner, I would have one of my clients sign this document on October 1st. Yes, ma'am.
Where?
So the question that I have regarding the damages cap is obviously the listing agreement would mean, obviously it's the agreement between me, my broker, and the seller. So I understand that, and I understand it being in the BBA. But what about those buyer's agents that don't have a BBA? Because
If
obviously,
you don't have a BBA, there is no way I can contractually limit the amount of damages that you potentially have because you don't have an agreement. The only way to do this is via contract. So there's no way for me to limit your potential liability and damages unless I do it in writing. So I can't tell you to use a BBA. What I can tell you is this is a benefit for using one, and you'll have to make that decision. Individual brokers will have to make that decision. But there's no way, because this is essentially the parties giving up a right. If I'm your seller, you're my listing agent, I am giving up my right to sue you for millions of dollars. So we're contractually agreeing to that. So it's got to have offer, consideration, acceptance, all that fun stuff, because it is a waiver of ability. So I don't know how to do that without the document.
so would there, I mean, I understand the RPA is an agreement between buyer and seller, and listing and seller's agents are just third-party beneficiaries of that
I
contract.
don't even know if they're third-party beneficiaries of that contract.
I mean, as commissions bind, they would be third-party beneficiaries for the commissions earned or whatever.
So-
I mean, just because I'm dealing with a specific performance lawsuit,
Yes.
where a seller's not paying, but that's besides the
So,
point.
Could
that be in the contract?
Can I just kind of, because I think what you're asking is why isn't there a damage cap in the RPA protecting buyers and sellers agents, right?
Yeah.
The answer is this is the document that it needs to be in, because this is where the discussion about the contractual obligations between the buyer and the buyer's agent and the seller and the seller's agent are created. I thought about putting it in the RPA. I don't think it would be as enforceable as having it in a listing agreement where that contractual obligation is created. I thought about it. I just don't think it's going to be enforceable before a judge with a damage cap because of the fact that I'm not sure if the agents are third-party beneficiaries to the contract. There's not specific language. I thought this would be the best place to put it. It's pretty common, for example, on the East Coast, this provision is in all listing agreements and buyer brokerage agreements. So we thought we'd put it here. I didn't think as an attorney it would be enforceable in the purchase agreement. And so I wanted to put it in a place where I thought it would be the most maximum, the most effective, which is the reason why it's where it is. If the law changes, then I think that I can put it in the purchase agreement and certainly reconsider it. But it's a very valid question.
Yeah, that was my only question, because for me, a lot of buyer's agents use a BBA. I've never used one ever.
You know, and I understand, there are pros and cons to using it, I certainly understand. I just, because what I would hate to do is put it in the purchase agreement, have you all rely on it, have someone sue over it, and have it be thrown out because of a variety of reasons, which I think are pretty valid. So that's the reason. You'll have to decide whether or not you're going to have a BBA. Okay, that's all of the forms updates. Oh, we got one question, so don't applaud yet.
Back to the damages cap.
Yes.
Is that on the total commission that's being charged in the transaction, or just
The amount, so if it's in the buyer brokerage agreement, and it would be limited, so I sue you, I'm your buyer, I sue you as my agent. The only amount, if I win, all I would be entitled to is what you received as the buyer's broker. Does that make sense? So it's not the total amount of commission. If the total amount of commission was $10,000, it would only be the amount that you received. Does that make sense?
unless you work both sides of the equation?
Then you better have it on both sides if you're right.
I just wanted to mention that Neil Schwartz of the Real Estate Division is teaching a course on the use of the buyer brokerage agreement.
Okay, thank you. Any other questions? Here. Yeah. So I want to, just as a side note, please, can we give a nice round of applause for the basically drafted her into carrying the mic, so let's please give her a round of applause. Thank you. These forms go live on October 1st. Have a great weekend.